MAIMS 6th National Moot Court Competition 2025 in collaboration with Bar Council of Delhi. We are very honored to have a learned bench. We welcome you judges. Before starting with the argument, we would like to brief the bench about the functioning of the courtroom. I, Palak Patel, will be serving you as Court Master 1 and will be assisting you with maintaining the decorum of the courtroom. And Vedika Kapoor will be serving you as Court Master 2 and will be assisting you with time moderation. Further, as already stated, there will be 2 court masters present in the courtroom at all times to assist the honorable bench. The court masters will act as facilitators between the bench and the counsels. The court masters will time the arguments and notify the bench accordingly. The judges are requested to please seek our assistance whenever it is required, and also judges are requested to please provide their valuable feedback to the teams when the rounds will be concluded. As stated in Article 80 with reference to Article 76 of the MAIMS 6th National Moot Court Competition 2025 rule book, each side shall get a maximum time of 45 minutes to present their arguments, of which no speaker shall be permitted to address the bench for more than 25 minutes. The time limit is inclusive of the time for rebuttals or surrebuttal respectively. The maximum time for rebuttal is 4 minutes and the maximum time for surrebuttal is 1 minute. Each speaker is required to speak for a minimum of 20 minutes, exclusive of the time taken for rebuttals and surrebuttal. The order of presentation is Petitioner Speaker 1, Petitioner Speaker 2, Respondent Speaker 1, Respondent Speaker 2, Rebuttal Petitioner any one of the 2 speakers, Surrebuttal Respondent any one of the 2 speakers, where surrebuttals will be permitted only at the discretion of the judges. The team code for the petitioner is TC54 and the team code for the respondents is TC07. The total time of the round is 90 minutes and each side will be presenting their side for 45 minutes, with petitioner speaker 1 presenting their side for 21 minutes and speaker 2 for 21 minutes, whereas the respondent speaker 1 presenting their arguments for 23 minutes and speaker 2 for 21 minutes. I now would like to seek the permission of the bench to start with the proceedings. Thank you, judges. Much obliged. I now request the petitioner to start with the proceedings.
Greetings to the honorable bench. The council humbly represents the gracious presence of the lordships and ladyship. However, for the convenience of proceeding, the council seeks permission to address this honorable bench collectively as a lordship. Much obliged. The lordship council 1 for the petitioner will be dealing with issue number 1 and 2, and my co-counsel will be dealing with issue 3 and 4. The council seeks permission to briefly state the facts of the case to the lordships. Much obliged. The lordships, the Union of Fred suffered a major terrorist attack in the region of Pasha. That resulted into 38 deaths and critically injured 60 persons, over 60 persons, your lordship. The lordship, the attack that has happened targeted a convoy which included tourists, pilgrims, journalists and security personnel that were heading to an international conference. In response to that attack, your lordships, the government of Dept launched an operation foregoing one force to dismantle the terrorist organizations that were involved in this case. During the investigation, your lordships, Ms. Shibon, the petitioner in the present case, who is also a journalist and influencer by profession with a large social media following, came under scrutiny for allegedly supporting the terrorist networks involved in this case. Later, your lordships, she was arrested and her digital devices were seized without a warrant, where she was suspected of harboring of a digital coordination in financial transactions. Further, your lordships, her biometric data and device passwords were also forcibly taken without court's authorization. Further, your lordships, she was also denied access to legal counsel for 36 hours. In that response, she has filed petition before this honorable court contending that they violate her fundamental rights. If your lordship is satisfied, the council seeks permission. Much obliged. Your lordship, regarding the first issue, the question at hand is whether the petitioner's digital activities amount to abetment of terrorism under UAP and BNS, or whether they are protected under the robust embrace of digital expression. Your lordship, the counsel for petitioner will submit argument under this issue in mainly 3 folds. Firstly will be the absence of intentional aid or that of actual knowledge on part of the petitioner. The second will be the very inconsistent nature of the chain that has been established by the state to allege the petitioner involved in this case. And lastly will be the protection that has been offered through the constitution, your lordships. The lordship, regarding the first submission, section 39 of UAPA provides that a person who commits the offence relating to support given to a terrorist organization must have the intention to support those activities, your lordship. Correspondingly, in BNS, section 113 subsection 3 requires the essential element of knowledge or that of direct intent to in order to prove the offence of abatement, your lordships. However, in the present case, the petitioner lacks the very important element of intention or that of actual knowledge, your lordship, which can be proved from the very fact that the information that has been shared by the petitioner forms part of a routine journalistic activity, and moreover the information that she shared was already accessible in public domain through media reports, civilian footages and other such posts, your lordships. Further, there is no evidence that the petitioner shared such information with the purpose of facilitating the terrorist attack, your lordships. The lordship, the essential of intentional aid through cases such as Twaha Fasal versus Union of India, which has been annexed at P18 of the compendium that has been submitted by the councils, presupposes that the accused must have rendered the assistance with the knowledge to further the concerned act, your lordship, in the present case, the terrorist attack. However, in the present case, your lordship, the state has failed to materialize any actus reus on part of the petitioner or any mens rea demonstrating that either she knew of or she intended or she directly assisted in such terrorist activity, your lordship. Your lordship, even the element of actual knowledge as recognized in the case of Ranjit Brahmajit Singh versus State of Maharashtra annexed at P4 of the compendium submitted was clearly absent on part of the petitioner, let alone the requirement of intention, your lordships. Moreover, your lordships, mere resharing or republication of the material that has already been available in the public domain cannot be arbitrarily materialized into having actual knowledge to abet. Your lordship, when a matter becomes a subject of public record, it becomes a legitimate object for comments by press and media, as also highlighted in the case annexed at P1 and P2 of the compendium, your lordships. Your lordship, hence, her lawful commentary, which she expressed through her social media platforms, are covered under 19(1)(a) and 19(1)(g) of the Constitution of Dept and cannot be disguised into having abetted the offence of terrorism, your lordships. Your lordship, regarding the second submission, the council will address the instances that have been mentioned in para 9 of the proposition as alleged by the state to be the instances of terrorism, your lordship. Your lordship, regarding the location tag videos, firstly, your lordship, the highway was an open, civilian accessible and public space, the location of which could easily be found through basic search engines or geotagging application, your lordships. Moreover, your lordship, it was a casual reporting, since the DJ at the highway in the present case bore no special significance before the attack has happened, your lordships. Your lordship, the petitioner act therefore amounts to nothing more than casual reporting or resharing of the publicly visible surrounding, your lordships, in the first instance. Secondly, your lordship, regarding the drone footage that the petitioner has shared, it was not a live reportage or sharing of a real-time visual or real-time data of information sharing. Hence, and also the information, the drone footage was already available in the public domain, and hence she cannot be solely liable for sharing of that information. Thirdly, the routine map that has been shared by the petitioner mentioned in para 9 of the proposition, your lordships, was in context of a story which she has posted upon her social media platforms, is covered under a journalistic privilege provided through 19(1)(a) and 19(1)(g) of the Constitution of Dept, your lordships, in context of the region's militarization. Your lordship, her intent was to critique the prolonged troop movements in the region and not to facilitate any unlawful activity that was done by a terrorist organization, your lordship. Additionally, your lordship, regarding the WhatsApp forwards that she has shared, they were, by their very nature, your lordship, they were the forwards in nature and have been forwarded by many other people even before petitioner did. And hence, your lordship, the mental element cannot be inferred merely from the nature of information, but must also be proven from the purpose behind sharing it. Lordship, the purpose behind sharing this information was mainly to inform the public regarding the information that was already circulating before. Hence, your lordship, since it has already entered into public domain, it became a subject of discussion, and the petitioner is well within her rights to provide an opinion about it on her social media platforms. Lastly, your lordship, the last instance that has been cited in the proposition regarding the telegram moderation. Regarding this, the satellite screenshots that have been shared can easily be accessible through public APIs, your lordship, which is a lawful and legal means of accessing or having information. Your lordship, moreover, the information sharing was done by the group admins and not by the petitioner herself, your lordships. Moreover, your lordship, she was not the one interacting with the anonymous PRF related accounts. It was the group admins who were interacting with these accounts, PRF accounts. And hence, any liability imposed upon her that she was interacting with it or she has a coordination with these PRF affiliated accounts is clearly far-fetched, Your Lordships. Your Lordship, regarding the third submission in this issue, it is that the petitioner's action are protected under her digital expression ensured through 19(1)(a) and 19(1)(g) of the Constitution of the Your Lordship. Your Lordship, in context of the charges imposed upon her, her professional background must be given due consideration, which is also mentioned in para 8 of the Moot proposition, Your Lordship. Your Lordship, she was a journalist and influencer by profession, and her work as a journalist often involves compilation, curation, analysis of the information that is available to inform the public and start a legitimate public discourse, Your Lordships. Your Lordships, reasonability of any restriction that can be imposed by the state or investigative agencies must be used in a qualitative, quantitative and relative sense, which was also stated in Anuradha Vasan versus Union of India and measured at P5 of the compendium submitted. Your Lordship, in that regard, her shares were authentic, procured from the sources that were already available in the public domain through civilian footages and media reports, Your Lordship. Her digital activities, Your Lordship, were not performed with the intention or with the knowledge that she was supporting a terrorist organization, but were conducted as a journalistic conduct that has been protected by this Honorable Court many a times. Hence, Your Lordship, in absence of any intentional aid or that of knowledge, actual knowledge for that matter, Your Lordships, she cannot be arbitrarily materialized into having supported these terrorist organization and under the provisions of abatement of terrorism, Your Lordships.
Why did she make public the route map of army movement? What journalism it is? And even their stopovers, wheel breaks. What is the purpose?
Your Lordship, her purpose as a journalist was to inform the citizens or start a legitimate public discourse regarding the information that has already been available in the public domain.
Why public discourse on this? Why should it not be read as a part of her intention to disclose to people that look, this is the movement, you can attack there, and these are WhatsApp screenshots, right? So why would a journalist get into that?
Your Lordship, in that regard, the para number 2 states that the region after the abrogation of Article 20 was on track of development, etc., and there were no security violations or terrorist attacks. Your Lordship,
but that also shows that since this article was abrogated, was repealed, taken away, there was unrest.
Certainly.
So why would she provide fuel to the fire?
Certainly not, Your Lordship. If Your Lordship may kindly refer to para number 2, it mentions that there was no reported incident of any security violation or any terrorist attack, Your Lordship. The region was peaceful in nature and she did not had any reason to believe, which was also referred in Toha Fazal versus Union of India and Karkar Singh, that the person must have either the knowledge or the reason to believe that the person is supporting such organization. She did not have any reason to believe that what she is sharing could have helped the terrorist organization. Since in considering the region's background, Your Lordship, it was a secured place, as mentioned in the para number 3 of the proposition, that this was one of the most secure zones, the attack that has happened in the state of Pasha. Secondly, there was no security violation, no attack that has happened, Your Lordship. She did not have any reason to believe that the information that she has shared could be materialized by the terrorist into in the terrorist attack that has happened, Your Lordship.
She's claiming journalist rights, right? Does journalists have a duty also to ensure that whatever you are putting on air is likely to be misused by some organizations? Will her freedom be unlimited in this?
Certainly, Your Lordship. However, in the present case, it was the responsibility of the state also to comply with certain procedural safeguards. Your Lordship, the drone footages, regarding the drone footages, Rule 24 of the Drone Rules 2021 states that in urgent need, the state can declare any area to be temporarily red zone where the unmanned aircraft system flies, which includes drone for that matter, Your Lordships, mentioned in section Rule 2 ZB mentioning para number 4 of the proposition that the inference that a conference was to be conducted, the major international conference, Vision 2040, Peace, Progress and Plurality, Your Lordships. It is also to be considered in light of the conference that is to be conducted. She was reporting the conference, Your Lordships. And since the government itself did not prohibit that area for drones, she cannot be imported the liability that she is not allowed to use drone in that area. The council seeks permission to proceed with the issue. Much of it. Your Lordship, issue 2 is regarding whether the digital seizures that have been conducted by the investigative agencies without judicial authorization violates petitioner fundamental right or not. Your Lordship, council will submit arguments in mainly three folds in this argument. The first submission addresses the core difference in the domain of physical objects or of digital objects, Your Lordship. Your Lordship, the extended mind thesis annexed at A3 of the memorial compendium that has been submitted proposes at the end, Your Lordship. Your Lordship, the extended mind thesis proposes that some objects in the external environment can be a part of cognitive process and in a way functions as an extension of mind itself in the physical domain, Your Lordship. Your Lordship, there is a core difference between the nature and domain of physical objects and that of digital devices, which was also recognized in the US Supreme Court case of Riley versus California, annexed at P13, Your Lordships, para number 28 in that regard, where the court has said that the cell phones or any digital device for that matter differ in both quantitative and qualitative sense from other objects that might be kept on arrestee's person, Your Lordship. Your Lordship, physical devices, on the other hand, are finite and limited in what they reveal. You can only search upon or seize the physical objects as what is available. However, in case of digital devices like that of laptop or smartphones, what they offer is limitless or is limitless and infinite, Your Lordships. A smartphone, for that matter, is not merely a container of information; it is compilation or compendium of a person's existence, Your Lordship. Your Lordship, digital devices are an interface of information and privacy, which has also been recognized in case Puttakwami versus Union of India, annexed at P23 of the compendium submitted, Your Lordship. Your Lordship, hence there exists a difference between the domain of digital devices and physical objects, and hence that the issue must be considered in light of this difference, Your Lordships. Your Lordship, second submission of the council is regarding the pending writ petition before this honorable court, the criminal writ petition number 395 of 2022, titled as Foundation for Media Professionals versus Union of India. Your Lordship, in this pending petition, the court in one of the orders expressed grave concern about the lack of a structured framework that governs digital searches, seizures, especially that of journalists, Your Lordships. In that case, Your Lordship, Justice Sanjay Kishan Paul, while stressing the importance of protecting journalists from arbitrary searches, observed, and the council quotes, these are media professionals who will have their own sources among other things. If you take everything away, there is a problem. Unquote. Your Lordship, the court categorically noted in this case that it is difficult to accept some of the all-knowing powers that these investigative agencies have. Hence, Your Lordship, the seizures that were done under Operation FOF by the investigative agencies, these are conducted against the safeguards observed by this honorable court in one of the orders, and cannot claim constitutional legitimacy merely because it was statutorily permissible, Your Lordships. Your Lordship, what the council is not questioning the statutory power of the investigative agencies to seize the devices. What is challenged is the manner in which the authority has administered, Your Lordships. Your Lordship, there are hundreds of journalists whose digital devices are taken en masse every day, Your Lordship. The issue raised in this petition are very significant in that regard, Your Lordship, because there are no guidelines with the reference to when and what may be seized, what can be accessed, and what protection is offered to the digital devices that have been seized, or the protection of digital data for that matter, Your Lordships. Your Lordship, the footprint of digital footprint of a person is upon that device, Your Lordships, and it is not like a person can have backup when the devices are seized. Your Lordship, the bench in that case also talked about balancing of interest between the need to search and the prejudice that is caused while seizing that devices to the person whose devices are seized. Your Lordship, the court itself in that case acknowledges this legal grey zone where existing provisions in the statute do not adequately address these uniquely envisioned nature of the digital devices, since it has been technology is emerging day by day, and we need a certain guidelines regarding the same. Your Lordship, in this regard, in Wishbone versus Union of India, the present writ petition before this honorable court, the decision conducted were within the same vacuum, the legal grey zone area, that the Supreme Court has warned against, as the Council has already quoted, cannot claim constitutional legitimacy merely because they were statutorily permissible. Your Lordship, the silence of law regarding the guidelines do not restrict the Constitution's command of reasonability and proportionality. Your Lordship, the Council's third submission is regarding the failure of proportionality test observed by the investigative agencies. Your Lordship, in case Puttaswamy versus Union of India, which is annexed at P20 of the compendium, Justice D.Y. Chandrachud has expounded a triple test when the investigative agencies can encroach upon the fundamental right. The triple test includes legality, legitimacy, and proportionality. Your Lordship. Your Lordship, in that regard, the investigative agencies have utterly failed to maintain the standard of proportionality that has to be maintained. In that regard, if Your Lordship may kindly refer to Annexure P15 of the compendium, Association for Democratic Reforms versus Union of India, the landmark case, wherein the test of proportionality was expounded, which contains the four-factor test, Your Lordships. The first is the legitimate aim of the state to counter it. Second is the rational connection between the two. Third is the necessity or the minimal impairment. And lastly, but not the least, balancing between the right and the restriction. Your Lordship, in that regard, even if the two limbs are assumed, the legitimate aim and that of rational connection between the act and the object, Your Lordship, the state utterly fails on the third and fourth limb, the necessity limb and the balancing limb. Your Lordship, firstly, addressing the necessity limb, it requires that when multiple means exist to achieve the same aim, the investigative agency or the state for that matter must adopt the least restrictive means. And in the present case, Your Lordship, the least restrictive yet equally effective means was to obtain a judicial warrant in the present case, Your Lordship, before seizing petitioner digital devices. In that way, Your Lordship, the objective of national security and that of countering the terrorist attacks that were involved would have easily been achieved. Your Lordship, the same principle was also recognized by Justice Chandrachud, where he exclaimed, and the Council quotes, if the state action can be achieved by a less intrusive method to privacy, that test must be adopted. Unquote. Your Lordship, investigative agencies' failure to seek this prior judicial approval transformed the seizure from an act of investigation into a constitutional overreach that the petitioner has expounded in the proportionality test, which violates the very necessity limb of the proportionality test, Your Lordship. The Council seeks extension of a minute, Your Lordship. Much obliged, Your Lordship. Your Lordship, regarding the balancing test, the fourth test requires balancing of the extent of infringement and with the objective of the infringement. Your Lordship, it states that when measures adopted by the state annihilates the core of the right, instead of merely restricting it, the balancing test fails. In this present case, Your Lordship, the weighing scale of proportionality stands wholly tilted in favor of the state, Your Lordship. Because the digital devices that they have seized were not mere rule of function, Your Lordship. They were the very medium of her speech through which she communicated. They were the instrument of her profession through which she exercised. And lastly, they were the source of her livelihood, Your Lordship. She exercised her profession through that. In that way, Your Lordship, the state, the investigative agencies have encroached upon a fundamental freedom of expression in under 19(1)(a), freedom to practice his profession under 19(1)(g), and a source to livelihood under Article 21. Your Lordship, in Anuradha versus Union of India, annexed at P5, it settles, para number 34 and 35 are the relevant paras, settles that both speech and profession, when they are dependent on digital medium, they are constitutionally intertwined and protected, Your Lordship. Hence, Your Lordship, there was no, there was security violation and there were fundamental violation of the petitioner involved in this case.
Commission proposed to die. Much obliged to that. Greetings to the bench. Council 2 will be dealing
without user consent violates the DPDP Act 2023. The Council will be submitting arguments in two limbs. First, the violation of the Golden Triangle as mentioned in the Constitution, and second, the deficit of the DPDP Act, Your Lordships. So, coming to the first link, Your Lordships, it is most respectfully submitted that the metadata surveillance and financial trail tracking undertaken by the state without the consent of the petitioner is in violation of the Golden Triangle of Article 14, 19 and 21, and this absolute disregard of the constitutional mandate, Your Lordships, proves that the DPDP Act is a deficit of law. At the very outset, the Council would like to bring the court's attention to the Annexure S4, which provides for Section 4 of the DPDP Act. Your Lordships, the section, if Your Lordships are there, much obliged. Section 4 of the DPDP Act provides that personal data of the data principal can be processed under two heads. One, where the data principal itself may give consent for, and the word or has been used, or where legitimate uses has been provided under Section 7 of the same Act, Your Lordships. Now, while the Act itself provides consent as a protective mechanism, Your Lordships, the wordings of Section 4 makes it optional for the data fiduciary to seek consent. And this permissive use of the word or used between the two ways of processing of personal data ensures that the state can bypass consent altogether by either taking the consent or under legitimate uses. Your Lordships, a person cannot meaningfully exercise control if the consent can be unilaterally bypassed with the invocation of the term legitimate uses. As observed by 10-member expert committee headed by Justice B.N. Srikrishna as Annexure A1 in the compendium, Your Lordships. If Your Lordships are there, much obliged.
This committee is of which year?
Your Lordships. This committee was recommended in the case of K.S. Kottaswamy versus Union of India, and furthering that,
Which year? You have it? Which year? Alright, it doesn't matter. Forget about the year. The larger issue is that whenever these pronouncements and the legislative pronouncements, judicial pronouncements were made, that time the extent and the nature of crime was completely different. Today it has reached beyond certain proportions. Don't you think that this may not be relevant as of date?
certainly, Your Lordships, however, in the present case, there is no intention or knowledge on the part of the petitioner, and moreover, the committee was set up to recommend a Data Privacy and Privacy Act for the nation, which today we know as the DPDP Act. The DPDP Act, when the name suggests protection of personal data, it omits of all procedural safeguards. Not even the decision where even the PUCL judgment recommended that Section 5 of the Telegraph Act included the same provisions as the DPDP Act, that in the name of sovereignty, security and interest of the state, the same can be omitted. However, no reason is to be provided by the state when such processing is done, and no requirement of the consent of the
But then
data.
the other provision says consent. Why would she consent for it? How will they investigate?
Certainly, Your Lordships, the PUCL judgment as well as the B.R. Srikrishna Committee provides a district judge may be appointed who may in a time-bound manner process all these applications for non-consensual processing of data. The same could have been done here and could have been provided in Section 17 of the Act, Your Lordships. Much obliged. And I quote, as provided by the B.R. Srikrishna Committee, that it would indeed be odd if a law enacted to give effect to a fundamental right of privacy does not serve to protect persons from the privacy harms caused by the processing of personal data by the state itself, Your Lordships. Thus, the impugned provisions vest unfettered discretion in the hands of the executive by bypassing all consensual mandates and omits any procedural safeguards, independent oversights, and it is thus inherently arbitrary and is thereby violating the Article 14 of the Constitution. Now, the B.R. Srikrishna Committee in this regard as well observed that there exists a public interest in unrammed dissemination of the information when such journalists analyze issues of public importance and inform and criticize and review about it.
What is the public importance in the movement of troops and their stopovers and meal breaks? What is public importance in this?
Certainly, Your Lordships.
Except that you intended to send a message that look, this is the vulnerable spot there, they can be hit. So why this kind of protections and rights be kept in mind?
Your Lordships, the petitioner was an UX-based, a different state-based journalist, and she was there at the Pasha in respect to the conference that was going to take place. And as already mentioned by my co-counsel, that the para 3 mentions that the place was already secure and heavy forces were deployed. So the petitioner was only there to cover the vision.
One question. Problem says her account received an unusual donation of 5 BTC from a wallet linked to dark web forum 5 days before the attack. All these articles and postings are also from 14th to 21st. Attack is on 26th. Right? So is it not all pointing to a preparation? Why was this donation received by her through dark web?
The leaderships, firstly, as the name suggests, it was a donation and not a form of consideration. Secondly, the leaderships, as a journalist, she has a right to receive donations to pursue her journalistic activities.
From dark web?
The leadership to protect her sources of information. She has all the rights to receive from dark web to protect her sources who donate.
For what? Sources for what?
To protect the donation, the sources who donate her to continue her journalistic activities. Furthermore, the Lordships, Article 21, which protects the personal liberty against the state action, except in procedure established by law. This expression does not mean the procedure that has been established in the statute, but one that is fair, just and reasonable and not arbitrary or oppressive. Section 17, Your Lordships, it provides blanket exemption to the state from its core obligations of consent or notice, and thus it provides an open-ended exception without no mandated prior authorization, no particularized reasons, or no mandatory report of reasons as well, which is a part of principles of natural justice, Your Lordships. It is the view of the B.R. Sri Krishna Committee that the data protection law must contain adequate safeguards to adhere strictly to the judgment of K.S. Kotoswamy versus Union of India, and recommended for both judicial oversight as well as parliamentary oversight, Your Lordship, so that there must be checks and balances in the need of ex-ante access control as well as ex-post accountability, Your Lordship. For the former, the committee recommended a district judge may be appointed so that all approvals may be timed-out for all non-consensual processing of data. And it is therefore my humble submission before Lordships that when the recommendations of the Justice B.R. Sri Krishna Committee, which laid the very foundation of the Data Protection Act, Your Lordships, have been completely disregarded in its final formulation, the DPTP Act is arbitrary and is constitutionally infirm. This Honorable Court in PUCL versus Union of India in Para 1 as annexure as P16, Your Lordships. As Para 1, the court observed that tapping of telephones is a serious invasion of privacy, and so is the non-consensual processing of data in the present case. The court in PUCL as in Para 35, Your Lordship, insisted upon complying on procedural safeguards, including prior approval from high-ranking officer and periodic review by the review committee in matters of surveillance. By contrast, Your Lordship, Section 17 omits all such safeguards. And hence, Your Lordship, to conclude on both limbs of this argument, it is very ironic when the legislative title itself promises to protect the personal data of the citizens, yet it does not provide any citizen-centric safeguards. And the Act permits the state to appropriate and process personal data of data principals without consent of the data principals, and thus the protection in its very title, Your Lordships, is a merely dream of users, and the Act provides everything except the protection of personal digital data of the data.
Have you challenged the constitutionality of this section? I don't think so.
Your Lordships, the petitioner does not mean to introduce a new dispute. However, the only safeguard.
If you have not challenged constitutionality, you're wrong, right?
If your Lordship may provide the answer. Petitioner has not introduced a new dispute, however, but merely asserting that the very statutory provision invoked by the state, that is the section 17, is ultra vires of the constitution, and therefore.
That's why I asked you. Have you sought it to be declared ultra vires?
Your Lordships, what we
I don't
have.
think so. This is not your own issues.
Certainly, Your Lordships, however, the Council has prayed that the exceptions in section 17 must be altered so that there are some certain safeguards for the data principles. The Council takes permission to proceed with issue number 4. Much obliged, Your Lordships. The issue number 4 deals with whether Ms. Shibon should be released on bail or not. Your Lordship, it is my respectful submission that by general rule, bail is the rule and jail is the exception, as which was observed by Justice B.R. Krishna Iyer in the landmark case of State of Rajasthan versus Bashan, and this very rule was also observed in the cases of UAPA in the landmark judgment of Jalaluddin Khan versus Union of India, which is annexed as P28, para 21, Your Lordships.
Yes.
Your Lordship, this judgment as well in para number 21 provides that even in cases of UAPA, even if the case is made out where the grant of bail and there are serious allegations, in cases of UAPA also, the rule remains the same, that bail is the rule.
What were the facts of this case?
Certainly, Your Lordship, in this case, the person was charged with conspiracy and terrorism again in the UAP, and the bail was rejected by trial court and high court. However, the Supreme Court observed the same, that the rule remains the same, where the bail is the rule and jail is the exception.
What was his role? What was evidence against him in this case, which you are referring to?
Certainly, Your Lordship. Your Lordship, the facts also included that certain evidences were recovered, but however the trial was prolonging, and that is why the reason this observation was made.
One question, you are arguing on bail.
Certainly.
Is that one of the relief claims by you? Is it a relief claim?
One of the issues by us and read by us is that, Your Lordship.
It's a writ. Is it a writ petition? What have you filed?
A writ petition, Your Lordship.
In a writ petition, you are asking for bail?
Due to the prolonged incarceration, Your Lordships.
Filed a writ petition in the Supreme Court seeking ultra-virus, IT and telegraph tools to obtain judicial oversight mechanism, journalistic privilege, compensation. These are the relief you are seeking. So why are you addressing arguments on bail when it is not a relief claim in your writ petition?
Your Lordship, the Article 32 under which we are petition over here, and this one of the writs that we have filed is of habeas corpus as well, and because of that we are seeking bail.
But habeas corpus won't operate if it's a case of bail. 2-3 days back, Supreme Court held. Habeas corpus says you don't know where the body is. Bail is you know that this is the offence in which he
Your
caught.
Lordships, if the council is not wrong, it was a case where the bail was rejected multiple times, and only then the court ruled observed that.
It was a writ of habeas where they said where you can seek bail and you know where the person is. There is no question of habeas corpus. What is habeas corpus? Habeas corpus is you do not know where the person has gone. But once you know that the person is in jail, there is a question of habeas corpus. So there is a case of illegal detention and you want to release. Here also you are giving illegal detention and therefore her constitutional right is being violated.
impossible status that the accused has to produce evidence to disprove the findings of the FIR. The court effectively conducted a mini trial and while ironically reprimanding the high courts for appreciating the evidences. It was held that the burden of proof on the accused was very high with respect to section 43D subsection 5 of the UAPA, contrary to the legislative intention, which did not envisage that the grant of bail becoming nearly impossible, Your Lordships. However, this Honourable Court in various judgments has tried to rectify the error made in the judgment of Batali, as was in the case of Sheikh Javed Iqbal versus State of Uttar Pradesh, where the court, in its para number 32, observed that the court should not conduct a mini trial, and the judgment of Batali was not to be considered as a precedent to deny bail. Crucially, even in the case of K. Najib versus Union of India, enacted at P27, and the relevant para being 70, it was held that the statutory provisions such as that provided of bail in the UAPA does not restrict the power of the constitutional courts by granting bail, keeping in mind the part 3 of the constitution, and hence bail can be granted in cases where the likelihood of trial being concluded within a reasonable time is slim, and prevent this section 43D subsection 5 being the sole criteria to deny bail. Pertinently, having stated the law, the threshold of section 43 subsection 5 says that proving a case on prima facie grounds, on reasonable grounds, that the petitioner in present case has not committed an offence. Now, the counsel, without appreciating the evidences, would prove a prima facie case. The materials uploaded by her, Your Lordships, was rather than being a secret, were already circulating in the public domain, and the state, this has aggravated by the fact that the state has failed to find the actual originator of the information, since the para number 9 of the fact sheet itself mentions that the WhatsApp forwards were there. Further, Your Lordships, the article, the title, Footsteps on Snow, Armed March Returns, mentioned in, was a legitimate expression by the petitioner in furtherance of her journalistic privileges and to present her ideas and expression, as para 2 of the fact sheet mentions that there was already peace and there was no terrorist attack after the abrogation of Article 20, Your Lordships. Likewise, the mere facts, the mere word used, that was donation, it itself cannot be reprimanded to the fact that it was consideration of quid pro quo to the material shared by her online on her account. And this is substantial of the fact there was no further subsequent utilization of the procedure, Lordships. Thus, the absence of direct nexus between the conduct of petitioner and the alleged offences reveals the attempt of the state to prosecute the petitioner is absolutely unfounded on principles of reasonable grounds, but merely on suspicion. And this absence in the credible material, the utter failure of the state to implicate the petitioner is a story that has been well crafted to make her a scapegoat, Your Lordships. It is also pertinent to note that an overwhelming majority, that is 97.5% of the people arrested between 2016 and 2020 under the anti-terror law have been imprisoned for multiple years while awaiting trial. Only 212 out of more than 20,000 were convicted. And even the pendency record in the cases of UAPA is about of 95% as opposed to general offences, that is of 40 to 44%.
Do you know why this rate of conviction is so low?
Certainly, this is because the investigation takes time, and
No, it is because if we release this kind of a lady, tomorrow she'll threaten all the witnesses, people will turn hostile, again acquittal. I'm still on my question. You talk of journalistic rights. Give me one good justification. Why would she need this route of the army movement and their stopovers and meal breaks? On this you satisfy us.
Your Lordships, firstly, with respect to the question, even Barkha Dutt shared live footages of the terrorist attack. She was never prosecuted. In Ajmal Kasab case, only an observation was made, but there was no prosecution, especially against her. Her liability was even higher because she reported all the live events which helped the terrorist attack even more in an aggravated manner. The petitioner in the present case, prior to the attack, has shared this information on the public with respect to The drone footages, my co-counsel has already explained on the drone views, Your Lordships. With respect to the location tag videos, these videos are generally available on basic search engines, and we have apps today that provide geolocation marks on the images, Your Lordships. With respect to the route map of the movement, this was with respect to her journalistic freedom of the article. Since the conference, Your Lordships, if
Please continue.
much obliged. Since a very important conference was about to be held, and she, considering her background that is mentioned under para 8, Your Lordships, she was an anti-establishment commentator advocating for demilitarization, plebiscite rights and civilian accountability in conflict zones, and that is why, with respect to her journalistic freedom, she shared the route map of the army movements to substantiate upon her article.
One question. What is the material that was seized? What are the videos? There are 4 videos they are talking about. These are not articles. What are these videos about? These videos are 3 location tagged short videos and includes the drone footage of convoy rehearsal zones. So what sir is asking is very pertinent. Journalistic privileges you are claiming, but where is the article? We can't see any article of, she may be an anti-establishment journalist, but what journalism is there? Look at the evidence that is there against her. 4 videos with the co-accused, share, tracks, money, and where is the journalism coming in all this?
Your Lordships, if the council personally puts anything upon social media, it is.
This is not journalism. See, it just tell if there is an article which is anti-establishment, well, that is her journalistic opinion. But there is nothing like that. What is coming out of rules, sharing 4 days in advance, 5 days in advance, you are sharing that. Why would you share a route with another accused? See, there may be information in public domain, but you have selected only something of relevance to the 2 of us.
Certainly, Your Lordship.
Right? And he is scheming something. We will take out the information from public domain and use it the way we think it will work in our favor. So just by going on repeating in public domain would not help your case.
Certainly, Your Lordships, if Your Lordships may also look at the para 8 of the fact sheet, it also mentions that she has a YouTube podcast channel wherein Valley Voices, wherein she hosted Pasha activists, former militants, retired police officers and lawyers. And yet again, Your Lordships, the entire scenario is merely coincidental, and to
But
make her
even payments in bitcoins,
Lordships,
cryptocurrency, why?
to make her the scapegoat, she already shared.
Why she would allow cryptocurrency to be given to her? Why not? Regular cash. Cryptocurrency is not illegal, but still its transaction in India is looked upon with suspicion. Why do you, how do you protect that?
Certainly, Lordships, if Lordships will be using. Lordships, with respect to a notice by dated 7 March 2023, the cryptocurrency has been recognized under PML, and thus it is taxable also.
No, it is, everything is there. I'm not saying that it is not. But it is not a recognizable mode of transaction. It is taxable, but it is not illegal transaction also. But it is not a valid mode of transaction. Anybody can back out from it.
Certainly.
So why would somebody deal in cryptocurrency? Because that is something surreptitiously done. So this is where she is linked with the crime.
Certainly, Your Lordships, if it were a form of consideration, she was receiving cryptocurrency for sharing the information, why would she take it through cryptocurrency, which is something that is taxable and already available to the government?
It's not trackable.
It's not tracked.
Taxable is, it is, if she declares. If she doesn't declare, it's not trackable. It gets vanished.
Certainly, Your Lordship, it is also taken into the account that the amount of the valuation of the Bitcoin keeps fluctuating on a daily basis. And as already mentioned by the council, she has a right to receive donations from her sources to continue her privileges of journalism, Your Lordships.
Funding for her activity. And you were saying she's an anti-establishment.
Commentator, she has a right to...
Secret sources are funding her to do anti-establishment journalism.
Certainly not, Your Lordships. She also advocates for demilitarization and private plebiscite and civilian accountability in conflict zones.
If everything is peaceful, why plebiscite and demilitarization?
Your Lordships, as a citizen of the phrase, she has a right to advocate for all. The Council seeks permission to proceed with prayers. Wherefore, in the light of facts stated, issues raised, authorities cited and arguments advanced, it is most humbly implored before this honourable court that it may be pleased to declare that the activities undertaken by the petitioner do not qualify as abetment to terrorism under UAP and BNS, but constitutionally protected under digital expression. Declare that the digital seizures without the warrant under Operation FOF breach fundamental rights. Declare that the metadata surveillance and financial trail tracking without user consent violates the rights of the petitioner. Direct the Union to expedite the framing of guidelines for search and seizure of digital devices of journalists by investigative agencies. Declare that there exists deficit in the DPDP Act 2023 to protect the user consent with respect to the exceptions under Section 17. Declare that the petitioner be released on bail. And or pass any other order or direction in addition to that honourable court may deem fit in furtherance of justice, equity and good conscience, all of which is respectfully submitted. For this act of kindness, the petitioner shall be duty bound forever. It was an honour honourable to present.
I now request the respondent to start with the proceedings.
Council seeks permission to proceed. Greetings to the bench, may it please the court. The council on behalf of the respondent shall be representing the state. Council 1 shall be dealing with contention 1 and 2, whereas my co-council would be dealing with contention 3 and 4. Your Honour, if Your Honours are satisfied with that, the council would like to proceed with the argument. Much obliged. Your Honour, the council would like to submit their first contention, which is that whether there was a victim of terrorism and can Ms. Siobhan in the pertinent matter take the defence of Article 19. Your Honour, the council has divided this contention into two legs. First, dealing with abetment of terrorism. Second, that there was no freedom of expression in speech, and she has misused that freedom mentioned under Article 19 of the Constitution. Your Honour, the council would like to submit that in order to prove that there was abetment, it is essential for the council to state to prove that there was abetment first for abetment for terrorism. Your Honour, abetment of terrorism is mentioned in Section 113, subsection 3 of the BNS. Section 118 of the UAPA states punishment for conspiracy of terrorism. Your Honour, Section 113(3) is abetment. Abetment is mentioned in Section 45 of the Bharatiya Nyaya Sanhita. Your Honour, it has 3 subsections: instigation, second is conspiracy, third is intentionally aiding. Your Honour, the acts of the petitioner in the pertinent matter closely fall within the ambit of conspiracy and intentionally aiding. Your Honour, conspiracy is defined in Section 61 of the BNS. Your Honour, the proviso of Section 61 states that if there is no agreement, there cannot be any conspiracy. Your Honour, the factual matrix always in competitions remains silent as to what is the direct nexus. It is upon the state to derive the link from the facts. Your Honour, if Your Honour would please refer to the factual matrix, para 9. Your Honour, there are 5 established facts in the factual matrix which clearly provide a link, a circle closes the loop for the petitioner to be held accountable in the pertinent matter. Your Honour, para 9 states that between the dates of 14th and 21st of October, the petitioner in the pertinent matter, first of all, shared a route map of the army convoy. She shared WhatsApp forwards detailing their stopovers and meal breaks. She shared 3 location tagged videos of the GJ and RJ, coming down to para 12, Your Honors, she received an unusual donation of 5 BTC. Your Honor, the Council would like to submit that the conversion of 5 BTC into the currency is 4,55,51,034 rupees. Your Honor, the Council would like to submit that it is in fact an unusual donation not made on a daily basis. Your Honor, the Council would also like to submit that the fifth major point in the factual matrix is that she used TOR routing, end-to-end encryption, and she often used to get anonymous cryptocurrency donations from the dark web forum. Your Honor, the link which connects all of this is mentioned in para 12, which mentions that there was a decrypted USB stick containing 4 of the petitioner's offline stored videos found near that site. Along with that, Your Honor, the para 10 of the factual matrix mentioned that the digital devices which were received around that site contained the IP addresses and digital fingerprints. When these digital devices were traced, they led to the IP addresses and digital fingerprinting of the petitioner in the content matter. Your Honor, the Council would like to submit that the petitioners are clearly basing their contention on how the data was publicly available and how reposting that data is not illegal. Your Honor, the Council on behalf of the state would like to go fact by fact, allegation by allegation, dissecting every fact which we had in order to create a suspicion against the petitioner. Your Honor, first of all, the location tag videos. Your Honor, this entire data was included a drone visual. Your Honor, if Your Honor would just allow the respondent, para 6 of the factual matrix states that the attack which happened, if Your Honor is there with the Council, Your Honor, para 6 of the factual matrix states there were use of VPN and dark forum and use of commercial drone. Your Honor, dark forum was the place. In fact, a dark forum account connected with the enemy state of Zaristan is from where she received that donation. Drones were used in the attack, Your Honor. Drones were used by her to record that visual, Your Honor. Along with that, para 7 states that there were digital propaganda and information leaking channels which was derived by the committee, the investigation committee which sat after the attack. Your Honor, this digital propaganda and information leaking channels is corresponded with the fact that she shared information on her digital platform as well. Your Honor, the Council would like to put forward the most important fact of the factual matrix that she is a journalist with an LLM degree in conflict studies from London. Your Honor, this prior knowledge, as knowledge is very important for conspiracy, clearly proves that she had knowledge of the consequences of the data she was posting on the social media platforms. Your Honor, she has a fan base of 4.2 million people. 4.2 million people are constantly viewing her data, they are following her footsteps, they are seeing what is being posted. Even if we do assume that the data which was posted, as it is mentioned in the factual matrix, that the data which was the screenshots of the satellite images which were posted on the Telegram group, these screenshots were publicly available. However, Your Honor, to put that publicly available data in front of 4.2 million people itself states that you are putting that data on a spot under the highlight, under the spotlight, Your Honor.
How would you connect this lady with these with the terrorist attack? She has posted the data on the channels or YouTube, wherever.
Much better.
Now today there are so many institutes, universities, even the Delhi High Court.
Indeed.
We have virtual tour on our website,
True, Your Honor.
right? So virtual tour any terrorist can use, and tomorrow if God forbid some attack takes place, will you be able to say that the judges were a part to this?
Indeed, Your Honor.
How will you meet this?
Much obliged, Your Honor.
Because she has just uploaded.
Indeed, Your Honor.
You have not connected her in any of these aspects with the attack, actual attack.
Much obliged. Your Honor, the Council would like to submit that she had interacted with 2 PRF affiliated accounts which is mentioned in the factual matrix.
Interacted with person on X, those persons are connected with PRF accounts.
Indeed, Your Honor.
She may not have any knowledge that they are connected. She is a journalist. So
Much
she has so much of broad-based fan following.
Your Honor, she had interacted with them on an X platform which is earlier known as Twitter. Your Honor, it is now changed, known as the X platform. Along with that, Your Honor, the council would like to submit that there was a USB stick which was found near the site. Your Honor, this USB stick contains 4 of downloaded Miss Shibon's videos. What is interesting here, Your Honor, is that that USB stick was decrypted. Your Honor, now decrypted means when I send a data to another person, it is encrypted so that anybody in the middle cannot read my data. It gets decrypted when the person whom I want to send receives that data. The fact that it was a decrypted USB stick completely clears the fact that she wanted to send that data to the person who has the USB, which is why it was decrypted. Along with, if Your Honor have any question?
No, but that decrypted stick was recovered from one of the attackers.
Indeed, Your Honor.
And that attackers has in that decrypted script those videos.
Indeed, Your Honor.
Apply same thing here. This courtroom, there is a coverage on the YouTube, and some terrorist download from there has it has this decrypted stick.
Much obliged.
How will it connect us with that?
Indeed, Your Honor.
That is my question.
Much obliged. Your Honor, the council would like to submit that the accounts that she was interacting with have had the names of, namely, as it is mentioned in the factual matrix, last line, Your Honor, para 9, Resistance River Valley. Along with that, the name of the account, the second account was Pasha Ali. Your Honor, the council would like to submit, this is interesting because the name of the group, Telegram group, which she was privately moderating, also had the name of Dissent Dispatches, and she was interacting with an account which had the name of Resistance River Valley. Along with that, Your Honor, the council would like to submit that the dates of between which she was sharing data, it also raises a clear suspicion. How? Your Honor, 14th to 21st of October was the time where she was sharing the data. 5 days prior to the attack was the time when she received the donation. 26th October, the attack happened. The council would like to submit that all of data combined created a suspicion in the mind of the state or the NIA team at that time to investigate her properly. That is all the state here is contending. The council would like to submit that all of this data, when looked upon as a whole, does create a suspicion and puts her in a spot. All the state in the pertinent matter wanted to do was investigate so that there are no further casualties. Your Honor, on a weighing scale, in one side we had the lives and family of 38 people who died, 61 who injured, and on the other side we had a journalist who shared the convoy movements, the army movement. Your Honor, the council would just like to refer the fact stated by the petitioner of Barkha sharing sensitive information. Your Honor, the council would like to submit that even during that time, the Supreme Court did raise a question as to why she shared that data. However, we did share a blind eye. However, Your Honor, that mistake cannot be repeated again in the pertinent matter. The council would like to submit that the red zones, which the petitioner stated that the usage of drone cannot be within that red zone. The council would like to submit that there are multiple digital devices which their usage cannot be red zoned in a lot of areas. Still, they are misused. The council would like to highlight before the honorable bench using of a drone to shot such videos where the army is stopping, where the army is having their breaks, is not of any use for the public. Your Honor,
She has not taken those shots on drones. These are WhatsApp shots.
indeed, Your Honor.
Number two, if we look at her story, Footsteps, the armed march returns, she just wants to project that, look, army has again come to my state. So how do you connect her with the terrorist attack? Even money for that matter, for creating public opinion, one country pays to another journalist that need not necessarily be terrorist activity.
Much obliged.
This is my point.
Your Honor, the council would like to submit that these are very valid concerns of Your Honor in the pertinent matter. However, Your Honor, along with the condition of the state at that matter, it was important for the state to, least they could do was to investigate as to what was done. Your Honor, when we connect all these facts, it does create a suspicion what the state had in the pertinent matter.
But suspicion only you book somebody and send him to jail.
Indeed, not Your Honor. The counsel would just like to mention that she was just brought in custody for investigation. That is all what the state wanted to do. Your Honor, we did file a charge sheet. Trial court did take cognizance of the offence. The trial was going on. Between all of that, the petition in the pertinent matter filed a writ petition against the very laws that she was booked under. The counsel would like to submit, if Your Honor would just allow, the judicial warrants that they are claiming which were not taken. Your Honor, the section 39 of the Bharatiya Nagrik BNSS, Your Honor, clearly states that there can be search and seizure with warrant and without a warrant. Your Honor, states utmost important criteria in the pertinent matter to investigate was national security. We have no problem following the procedure. However, the procedure that they are claiming to be followed is not laid down, Your Honor. Ram Ramaswamy guidelines or the Ram Ramaswamy petition is a running petition, does not have a judgment in the pertinent matter. The moment they pass that judgment with the said guidelines, the counsel affirms before the bench he will follow that. But by that time, we have to follow the procedure which is already laid down, which we did in the pertinent matter. If Your Honors would just allow to address the link which the Your Honors mentioned, Your Honor, in the Moot proposition, it will never be mentioned as a direct nexus. It is our job to extract facts from the case in order to create a contention. Your Honor, all the facts aligned, all the facts put one by one clearly creates a suspicion. That is why the state put her under discreet surveillance also, as it is mentioned in para 10, Your Honor.
You're not wrong on this, that we have to deduce from these facts, right?
Yes,
My only point is that while deducing,
indeed, Your Honor.
while making any inference, why should that inference be not accused-centric? Why should it be state-centric?
Much better. Your Honor, the counsel would like to submit this sort of terrorist attack does not ever take place in our country. Union of Threat is a very peace-loving state where such attacks have never happened. It was a shock to the state and its security when such drones entered the entire place. Your Honor, that is why it was important for us to investigate it as soon as possible. Your Honor, when seen the provisions, which is contention 2 also of the pertinent case, Your Honor, where digital devices seized inappropriately or unconstitutionally. Your Honor, we took 13 days to evaluate that entire data. Your Honor, there was 2 TB of data which had to be evaluated. Along with that, the investigation agency had created a red flag as to this particular account was sharing suspicious data, which is why we went to her house and to investigate her. Your Honor, after the investigation, we had to seize her digital devices to see as to what she is doing. And Your Honor, the counsel would like to affirm before the honorable bench that that seizure was not a failure. We found out that she had been using end-to-end encryption methods, TOR routing. Basically, Your Honor, TOR routing is when you want to mask your activities on the internet from the rest of the world. Your Honor, she had used such devices, such methods to mask her activity on the internet. This is what we had derived from the seizure of the digital devices, leading us to the method or the methodology which we follow to seize our devices. Your Honor, BNSS clearly grants the power to the officer in charge of that particular area to investigate or to search, arrest and seize such devices without warrant when there is a reasonable apprehension of them to them that such person had committed that crime. And when all the facts align, Your Honor, it does create a suspicion, which is why the counsel submits before the honorable bench and their due wisdom to consider the fact of the material that she had posted on her social media. Along with that, Your Honor, the counsel would like to submit that section 40, if Your Honors would just allow. Your Honor, she was booked under the UAPA and the IT Act. Your Honor, my apologies, Your Honor, the BNS and the IT Act. Your Honor, the counsel would like to submit that 43B and 43C of the UAPA states that all provisions of arrest and seizure under UAPA shall be done according to the Criminal Code Procedure, which is CRPC, now known as BNSS, which gives UAPA arrest under UAPA also the power to arrest, seize and search without a warrant, as it is clearly mentioned in section 39. Your Honor, section 45 also states that when there is arrest and seizure of a particular person, that device shall still follow certain steps. If Your Honor would just allow, Your Honor, the factual matrix states that all safeguard procedural steps were followed under national security. The council affirmed before the honorable bench that 38 lives had already been lost. It was our prime duty to not allow any other casualties. With that, Your Honor, the council would like to conclude their arguments by saying that the state in the pertinent matter had the responsibility of maintaining the national peace and security of the pertinent country. Along with that, we also followed safeguard procedures for the petitioner so that we do not violate her privacy also. However, Your Honor, to break a trial court, to break the flow of the trial court by delaying the procedure of filing a writ petition, that too a writ petition against the laws which were already for which she was charged, is a little inconvenient for the honorable bench as well. Your Honor, with that, the council would like to submit. Your Honor, it was an honor arguing before the honorable bench. With that, I would like to call upon my co-counsel to deal with contention 3 and 4. Much obliged, Your Honor. I will seek permission to approach the bench. Greetings to the honorable bench. May it please the court that is the council appearing on behalf of the state. The council shall be dealing up with the third and the fourth contentions at hand. Your Honors, the third contention deals with whether or not metadata surveillance and financial trade tracking without user consent violates the DPDP Act. It's most respectfully submitted, Your Honors, that the contention shall be dealt with in 3 folds. Firstly, that the section 17 exceptions of the DPDP Act are properly invoked and the state's actions fall squarely within them. Secondly, that the state's restrictions on the petitioner's privacy duly satisfy the proportionality test laid down. And lastly, that the state's actions are in the DPDP Act itself is in consonance with international standards and jurisprudence on digital privacy. Your Honors, beginning with the first leg of the contention. Your Honor, section 17 of the DPDP Act explicitly carves out exceptions, specifically section 17 under which the state has sought refuge. Your Honors, subsection 2, section 17, subsection 2, clause A, if the council may read the verbatim of the provision. Your Honors, it provides that processing of personal data by the state or its instrumentalities shall be lawful where it is necessary for the performance of any function under law or in the interest of sovereignty, integrity and security of the state. Furthermore, Your Honors, subsection 1 and clause C of the same section provides that provisions concerning consent do not apply where personal data is processed in the interest of prevention, detection, investigation or prosecution of any offence or contravention of any law for the time being in force in India. Your Honors, the surveillance that was surveillance and metadata analysis which was carried out, undertaken pursuant to this operation FOF, that was an anti-terrorism operation that was being taken up by the NIA. Your Honors, it is humbly submitted that this objective falls within the investigation of an offence under section 17. Your Honors, further it is contended, as my learned opponent counsels have highlighted, that section 17 lacks procedural safeguards. Your Honors, it is humbly contended that section 17 carves out exceptions that the provisions of the Act may not apply in these conditions. However, Your Honors, there are certain provisions of the Act which are immune to these exceptions. So those immunities do put some restriction on the state so as to not act abstractly. Your Honors, section 17 is immune to section 8 clause 1 and subsection 1 and section 8 subsection 5 as well. Your Honors, thus it is contended that the section 17 authority that is granted to the state to investigate in national security is not absolute. The authority granted to them is still under oversight and restricted, which leads, Your Honors, which leads the council to the second leg of the contention that the state's actions have the restrictions on the petitioner's privacy are duly proportionate. Your Honors, the Honorable Supreme Court in the landmark judgment of K.S. Puttaswamy versus Union of India laid down a 4-fold proportionality test. That if the state is putting any restriction on the privacy, they must filter through these 4 libs. The libs being, Your Honors, firstly, that the restriction must be sanctioned by law. Secondly, that there must be a legitimate aim for that restriction. Thirdly, that
that the action must have a proportionate and rational nexus with that aim, and lastly that there must be a necessity for that restriction. Your Honours, the Council shall attempt to justify the state's actions on each of these limbs. Your Honours, firstly, the state's actions find its footing in section 17 as has been already discussed in the first leg. Secondly, Your Honours, there is a legitimate aim. Your Honours, a crime as heinous as a terrorist act injuring 38 lives and killing 38 lives and injuring 61 amounts to one of the highest state interests, and the question of the state not having a legitimate aim may not be entertained, Your Honours. Thirdly, that there is a rational connection. Your Honours, it is submitted that the petitioner's financial trails were put
Just
under...
a minute. You said, if I'm not mistaken, you said that the fact that so many people have died, so legitimacy of the state action cannot be suspected. Is what you're saying?
Your Honours, much obliged, Your Honours, the Council is contending that since such major loss was suffered by the country, the state interest to prosecute and investigate in this matter becomes higher.
No. Can it not be possible that when we talk of legitimacy of state interest, that just to solve this problem, you are booking some innocent person just to close the chapter?
Indeed not, Your
So
Honours.
why should legitimacy be not tested strongly? You are state, you are not certain.
Much obliged, Your Honours. The legitimacy must be tested. The state has the obligation to satisfy each of these limbs. The state is no way evading any responsibility towards these limbs. However, the state is contending that it is logically derived that since there was a heinous terrorist attack, the state has a legitimate aim of investigating into the same. And
That's precisely my question.
indeed,
When we talk about these digital seizures without warrant,
indeed,
are you connecting it with the loss of lives? Loss of lives does not give legitimacy to state action.
indeed,
It gives legitimacy to your need to investigate,
indeed, Your Honours.
not the current case.
Indeed, Your Honours, much obliged. The urgency, the Council now fairly, if the Council understands the concern of the bench, the loss of lives calls for the urgency of investigation. However, the suspicion in the petitioner arises the legitimate aim. Much obliged, Your Honours. Council humbly likes to contend that all the circumstantial evidence which had pointed towards the petitioner raised the legitimate intention and interest of the state to investigate into the petition. The Council shall highlight how there was a rational nexus between the objective that was sought and the means that was adopted. Your Honours, the financial trails of the petitioner were tracked. Your Honours, the financial trails were relevant in the pertinent matter, as has already been highlighted by my co-counsel, that the petitioner had received an unusual donation. Your Honours, financial trail tracking reveals associations, patterns and behaviours which was actionable intelligence for the state and would have over time revealed who the petitioner is associated with, whether or not she has substantial relations and links in the PRF association itself. Further, Your Honours, the fourth limb of the test is necessity and balancing. Your Honours, as my learned opponents have highlighted, the principle of minimal intrusion. The Council humbly acknowledges this principle and understands that the means adopted needs to be least intrusive to the privacy, which is the very reason why the state has limited its actions to metadata and not actual data. Your Honours, it is humbly contended, if the Council may explain what metadata is. Metadata by very nature is information about the information, not the actual information. Your Honours, such as the duration of the call, frequency of the calls, the timing of the calls and the location from where the call is being made, not the actual content that is being spoken in the calls, which would amount to personal data. Your Honours, for example, further, to understand the concept better, for an example, an email is being sent. The actual content that is being sent from one person to another would be the personal data of that person. However, the time on which that email is being sent, to the person, to the sender, the receiver, the email addresses of those persons, further the location from that email was sent is the metadata of that email, Your Honours. It is humbly contended that, Your Honours, the definition of personal data. The DPDP Act deals with strictly personal data, and the definition of personal data is given under section 2T of the Act. If the Council may read the verbatim, Your Honours, personal data means any data about an individual who is identified by or in relation to such data. Your Honours, metadata does not inherently reveal the identity of a person. If the Council may give an example, the metadata deals with who, when and where, not the what. In that sense, Your Honors, the state has limited its actions to metadata since metadata does not even meet the statutory threshold of the DPDP Act. Metadata does not qualify as personal data, Your Honors.
But this metadata would show the communication between Shivan and someone else.
Indeed.
What that communication was, it may not be, right?
Indeed, Your Honors.
But that metadata connect is very much there.
Indeed, Your Honors.
So it is a part of that.
Your Honors, much obliged, Your Honors. How it might seem though that the duration of the calls and the frequency of the calls may be classified as personal data. However, the strict definition of personal data is given strictly to the identifiability in relation to such data, Your Honors. The person's identity cannot be identified through the duration of her calls, Your Honors. So it is hence contended that the personal data was never breached of the petitioner. It was only metadata, and it was relevant because it would over time, when combined with other data sets, reveal patterns and associations and affiliations. If Your Honors are satisfied with this argument. Much obliged, Your Honors. The Council only contends that hence these actions of state were not to put a blanket surveillance on the petitioner's life, but to narrowly tailor into the provisions that the state is allowed to work under. Furthermore, Your Honors, the last leg of the contention is that the DPDP Act is in consonance with the international standards on digital privacy. Your Honors, the petitioners have challenged the constitutionality of the statute itself, Your Honors. However, it is imperative to note that the international standards.
Constitutionality has not been challenged. Where is it there in the issues?
Much obliged. It is, as it has not been given in the proposition. However, the council is deriving.
Please tell me something. You have relied upon so heavily on this crypto transaction into her account.
Indeed, Your Honors.
Your state, why have you not so far delegitimized this transaction before you start using it as an incriminating piece of evidence?
Much obliged.
I need to understand why you have not delegitimized.
Much obliged, Your Honors. Since the same is a developing concept, with the due recommendation of the bench, the council shall take the same recommendation into account. However, the council is not at all questioning the legitimacy of the petitioner's transactions here. The council is only questioning firstly the amount of the donation. Your Honors, 4.5 crores is not a usual account that we deal with in every day. Secondly, Your Honors, the suspected linkage to the dark web forums and the enemy state. Your Honors, no journalist acting in good faith, in good intentions, needs to hide her transaction. Your Honors, the very intent to hide her means and activities shows that
Transaction crypto doesn't mean always hiding it. It may be a convenient mode of travel of money.
indeed, Your Honors, however, 4.5 crores, and this has explicitly been, my apologies, this has explicitly been stated that it is an unusual donation.
She is trying to mold public opinion that look, state is so much oppressive. What is wrong with that?
Much obliged, Your Honors. Council acknowledges this fact. However, had all of these things been isolated acts, it would have not raised a suspicion. What are the coincidences of all these things happening within 5 days of each other? She uploads these videos, she receives money for it, the attack happens, the attacker is found with her videos. All this points very substantially towards her, raising suspicions. Your Honors, the rest the council shall leave it to the due wisdom of the bench, whatever they deem fit. The council shall just highlight that the council was talking about the international standards. Your Honors, the assumption, any claim about the DPDP Act being unconstitutional is untenable since the DPDP Act mirrors the global consensus. Your Honors, the Constitution of India, a masterpiece that it is, it has never hesitated from borrowing from international jurisprudence. Your Honors, on that note, Article 23 of the European Union's General Data Protection Regulation, that is GDPR, which is often regarded as the golden standard of privacy. Your Honors, along with that, and next to that, Section 26 of the UK's Data Protection Act. There are provisions where in matters of national security, the state's authority becomes absolute. Your Honors, because the doctrine of greater good also exists, that on one hand we have the petitioner's right to privacy and freedom, which the right itself has a clause that it may be curtailed in the interest of national sovereignty and interest. And on one hand we have the petitioner's interest, and on the other hand we have the integrity of the entire nation. On that note, Your Honors, global consensus on digital privacy is that national security calls for extreme measures, Your Honours. Furthermore, Your Honours, the digital domain that is beyond geographical boundaries. It is important to note that what the international standards are saying about the same. Your Honours, so it is contended that the DPDP mirrors this global consensus and the same may be taken into account by this honourable bench. If Your Honours are satisfied with this contention, the Council seeks permission to move on with the fourth contention. Your Honours, the fourth contention deals with the bail application of the petitioner. This submission shall be advanced in three parts, Your Honours. Firstly, that the detention is backed by law. Secondly, that the grounds for denial of bail stand fully satisfied. And lastly, that the prayer for bail at this stage is untenable. Your Honours, dealing with the first leg of the contention, the petitioner has been charged under Section 18 of the UAPA, which is punishment for conspiracy, attempt or advocacy of terrorist acts. Your Honours, this provision makes it extremely clear that any acts of conspiracy or any perpetratory acts even are supposed to be dealt with just as much seriousness as the act of terrorism itself, which is the very reason why the Section 43D5 of the UAPA, that deals with the bar on grant of bail, has been kept extremely stringent. Your Honours, the Council will read the verbatim of the pertinent provision. No person accused of an offence punishable under Chapter 4 and 6 shall be released on bail if the court is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Your Honours, the councils, my co-counsel and I have attempted to present before this honourable court how the prima facie evidence all points towards the petitioner. Hence, the petitioner was put under custody. Your Honours, in this present case, the investigation agency has found material evidence and the same needs to be taken into account as prima facie evidence. Your Honours, the provisions of bail have been kept extremely stringent in this pertinent statute since it is a matter of national security. Your Honours, the Council would further like to reiterate the case law stated by my opponent co-counsel that the case of National Investigation Agency versus Zahoor Ahmed Shah Batali, Your Honours. In this very case, the petitioners have brought forth this case law. However, Your Honours, in this very case, bail was never granted due to the stringent provisions of UAPA. Your Honours, if the Council may briefly state the facts, the person was charged under UAPA and they sought bail on the ground that there are medical complications and the petitioner needs to take care of themselves outside custody. The court had said that the medical assistance shall be provided to them in jail, reinforcing that the stringent provisions of UAPA regarding bail are very strict, Your Honours, and the same may be taken into account. Moving on, Your Honours, to the second contention that there are certain grounds of bail that need to be satisfied and need to be taken into consideration
Before you proceed to that, please explain. If you say that there are stringent provisions of UAPA that bail can't be granted unless where there is a reasonable belief that she is connected to the crime. Will the fundamental right, Article 21, be superior or legislative bar would be superior? Can 21 not make inroads into that?
Much obliged, Your Honours. If the Council may highlight that every statute has to operate within the four corners of the Constitution and usually there is a presumption of innocence. However, acts like UAPA and even dowry prohibition acts completely shift the burden and then the provisions become more stringent and even the fundamental rights related to personal liberty have to be read in accordance with the statute. The statute and over the years, the interpretation of the statute and this provision, the legal precedents that have been set, which show that the provisions are very stringent and they do in fact, to an extent, curtail the petitioner's fundamental rights.
So you mean to say there's blanket ban on bail for UAPA even because the concern is that the way we know trial will proceed, trial take 10 years.
Indeed,
After 10 years if she gets acquitted, it will be another Nithari.
Much obliged, Your Honours.
Why should she be kept in jail?
Much obliged, Your Honours. If the Council may bring to the attention of the bench that in para 15 it is stated that this is the final hearing, which is the very third leg of the contention that the Council has brought forth. Your Honours, this matter is being argued before this honourable bench for the final hearing and the bail application is not tenable at all, Your Honours. It will serve no practical purpose.
No, it's not for final hearing.
If council may humbly differ, Your Honor. Para 15 clearly states that this matter is for the final hearing.
No, she has filed a writ petition. Please see para 14.
Much more to that in this proposition.
Para 14 says she has filed a writ petition.
Much to that, Your Honor. If the council, if the
Last says fine.
15th paragraph clearly mentions, Your Honor, that the Supreme Court, seeing the interest of justice that there exists substantial question of general public importance, transferred all the matters to itself and is listed before final hearing. Your Honor, that the,
Without trial.
uh,
Without trial, it has been taken by Supreme Court for final hearing.
Your Honor, the matter was under trial in the trials court. Everything was being investigated and the charge sheet was filed. The petitioner has challenged all the laws that she was booked under and directly come to the Supreme Court and unnecessarily prolonged the trial. And now that it's for the final hearing, in the writ petition, firstly, she is asking for bail. Secondly, this is the final hearing. Any application for bail cannot be entertained, Your Honor. And lastly, trial was ongoing, Your Honor.
Why should bail not be entertained in the writ court? Please state. Because ultimately it's a matter of writ is what? Writ is to protect your fundamental rights.
Much
You say my fundamental right is that my trial is being delayed, I should be released from bail. Why should
much obliged, Your Honor. In due interest of justice, Your Honor, Your Honor will do anything that they wish to do under procedures established by law, Your Honor. However, it is an established principle that when you seek a writ for a certain purpose, you apply the facts and prayers according to that. However, and further, it's also practical purpose to ask for bail on the final hearing, Your Honor. Given that, having said all of that, the honorable bench has the ultimate power and the say in every matter, Your Honor. And the same.
How do we have not the case yet? There is a
Much obliged, Your Honor. The honorable bench may, according to law, deem whatever they deem fit. However, according to the principle, Your Honor, when a specific writ is being sought, the matters are to be in consonance with that writ which is being sought. If Your Honor is satisfied. Your Honor, the council was contending that there are certain other factors that need to be taken into account before granting bail. Your Honor, the same grounds were laid down in the case law of Budikanti Nursing Guru versus Public Prosecutor, High Court of Andhra Pradesh in 1978. Your Honor, these factors were nature of the offence, severity of the punishment, likelihood of absconding, tampering with evidence, and potential threat to public order. Your Honor, firstly, the nature of the offence and the severity of the punishment is beyond dispute, Your Honor. It's a terrorist act and the maximum punishment is life imprisonment, thus classifying this offence into a heinous offence, Your Honor. Secondly, the likeliness of absconding. Your Honor, the petitioner has international digital networks. She has financial intermediaries who could easily facilitate her evasion, Your Honor. Further, there is a possible, as the counsel has highlighted, there is a risk of fleeing. Further, Your Honors, the significant portion of the evidence involved in this case concerns with the digital domain. If the petition is granted bail, she will go out in the public with access to any device. The counsel acknowledges that all the devices belonging to the petitioner are seized and in custody. However, the digital domain is of such nature that the data can be accessed through any device. The petitioner can easily tamper with that evidence.
She can be kept under surveillance. That's the job of the state. Why should not liberty be curtailed?
Your Honors, as this matter has become very sensitive, and the data, that is this primary evidence that the state has against the petitioner, it could be tampered with, Your Honors. The petitioner is being put under surveillance, Your Honors. There is a further issue that the petitioner was put under trial by media and her family is facing threats, Your Honors. Counsel would humbly request the honorable bench to take note that she is safer in custody, Your Honors, in the media.
Can somebody's liberty is curtailed? How can he be safer in custody?
Your Honors, it is important to note that she is a public figure and she has a possible threat outside, and the decision of not granting bail.
For that threat, it's the duty of the state to protect her. You can't curtail her liberty.
Indeed, Your Honors. However, the counsel would beg to submit that there are reasonable reasons to keep her confined. She could abscond. She could re-engage, Your Honors. One of the factors to be taken into account along with these are that the risk of engagement, re-engagement needs to be taken into account. She could, again, if the acts were done out of carelessness, Your Honors. If Your Honors, if the counsel may contend, there are two possible ways. Either the petitioners are contending that it was not intentionally given to them. Your Honours, then the petitioner is likely to re-engage carelessly in such abetment again. Further, Your Honours, if it was done intentionally, there is all the more reason to keep her confined. And since this is a final hearing, the judgment will come out shortly after and the same decision shall be taken. Why should the bail application be granted? Having said all that, the council shall leave it to the due wisdom of the bench, Your Honours.
My one question.
Indeed.
You say that in fact there is a threat to her and for her own security she needs to be kept at bay.
Indeed.
What is that concept? The state fails to give protection to an individual and therefore put them in jail.
Indeed not, Your Honours. The council was just contending, was answering to the concern of surveillance, Your Honours. The reason why the petitioner is a public figure, Your Honours, and she poses a significant threat to the society, and the media is also putting her on trial. The council is nowhere contending that an innocent must be kept behind bars, Your Honours. May that be humbly submitted. However, since the prima facie evidence is pointing towards her and the restrictions itself are all in favour of the state for her to not be granted bail, Your Honours. The council is not contending that the innocent person who has no evidence against her should be kept behind bars. The only reason that the petitioner should be kept under custody is her involvement in the case and the possibility of re-involving in this case and damaging the course of justice.
Alright, your state just answer one more question.
Indeed, Your Honours.
You say that they are terrorists,
Indeed, Your
right?
Honours.
They say we are freedom fighters, we want a separation from your country.
Indeed, Your Honours.
So how do you reconcile this? Why should you send them to jail?
Much obliged, Your Honours. If the council may humbly draw a difference between freedom fighting and terrorism, Your Honours, every citizen of India reserves their right to criticize the government. However, Your Honours, any act against the state is not tolerated, Your Honours. The petitioner has every right to be an anti-establishment commentator, hold any person that she wants to interview on her channel. She deserves the right to freedom of speech. We give her that, Your Honours. It is the constitutional guarantee. However, when this freedom of speech challenges and infringes upon the security of the state, then that has to be restricted as has been provided in the Constitution, Your Honours. If Your Honours are satisfied, the council seeks permission to move on with the fair act. Much in light of the facts of the case, issues raised, arguments advanced, and authorities cited, the council on behalf of the respondents humbly pray before this Honourable Supreme Court of Dept to adjudge and declare that activities of the petitioner qualify as abetment of terrorism and she should be granted maximum punishment under UAPA and BNS. Secondly, that the digital seizures carried out under Operation FOF are not in violation of her fundamental rights. Thirdly, that metadata surveillance and financial trade tracking does not violate the DPDP Act and further uphold the constitutionality of the DPDP Act. And lastly, that the petitioner should not be granted bail and or pass any other order that the bench deems fit in the interest of equity, good conscience and justice. And for this act of kindness, the councils on behalf of the respondents, as in duty bound, shall serve. Much obliged, Your Honour. It was an honour argument.
My one question is, this is a writ,
Indeed, Your Honour.
not a trial.
Indeed.
So how would the Supreme Court convict the person? Your prayer is that the lady must be convicted. In a writ jurisdiction, when you are questioning the legality of various statutes,
Indeed, Your Honour.
bail can be understood. When in fact it would not be a bail but would be a request for release, considering all
Indeed.
circumstances. But how can there be an acquittal in a writ?
Much obliged, Your Honours. If the council may bring to the attention of the honourable bench, the council acknowledges this principle and had sought the same clarification from the drafters of the proposition, and the same was provided that this matter has the Supreme Court has itself transferred all the matter before itself, and the council is bound by the proposition and has argued on the basis of the same. Much obliged, Your Honours. It was an honour.
I now would like to seek the permission of the bench to start with the rebuttals. Thank you, judges. Much obliged. I now request the teams to start with the rebuttals.
It is indeed an Your Lordship, ISP as submitted applies only to the central government organization and the associated organization and not to private individuals or citizens, Your Lordship, as submitted. There is a serious misapplication of these guidelines on part of the respondent, Your Lordship. Secondly, Your Lordship, my learned friend on the other side may argue otherwise, but the law is clear on the point that even a prisoner, as a matter of fact, has certain level of rights protected under Article 21. However, Your Lordship, there has been, the petition in this case has been robbed of these fundamental rights. As mentioned in paragraph 15 of the proposition, she was denied access to legal counsel for 36 hours. Your Lordship, not delayed, but denied. Violating Article 22, Clause 1 of the Constitution, she was further subjected to media trial. Her family was harassed, Your Lordship. The council questions the worthy counsels for the respondent that is this how they safeguard the citizens of their country, or is this how they safeguard the fourth pillar of the democracy, Your Lordship. Further, Your Lordship, regarding the Ram Ramaswamy case cited by Council 1 of the respondents, this Honorable Court has already coupled this case with the Foundation for Media Professional case which the Council herself argued. Your Lordship, this Honorable Court has already expressed their concern regard to that as the Council quoted in the submissions. And this Honorable Court has already directed the state to frame guidelines on 7th of November 2023, Your Lordship. Today is 22nd of November 2025, 2 years, Your Lordship. What they have been doing these 2 years. Lastly, Your Lordship, the opposing counsel has further referred to the name of Telegram group referring the petitioner to the terrorist organization, the Dissent Dispatches. Your Lordship, they have made the group name, Your Lordship. Do they mean now that you cannot even dissent in a country if when it is in a case, it is seriously protected under 91? Further, Your Lordship, as counsel number 2 has mentioned that she has access of the devices also, even though she has all the devices have been seized. Your Lordship, they have the passwords of our devices. What devices? What is the use of our devices when the passwords there? When they have the password, and how can we log in these devices, Your Lordships? Lastly, Your Lordship, regarding the bail condition, Section 51 of the UAP already applies for the automatic passport system, Your Lordship. Your Lordship, there is no flight risk of the petitioner in this case. It can be given as a bail condition, Your Lordship, but petitioner will not violate that. These were the submissions on part of the petitioner, and these are the questions petitioner seeks respondents to. Much obliged.
I also seek permission to approve the dash. Your Honours, regarding the concern raised by my worthy co-counsel regarding the delay of legal counsel. Your Honours, when the investigation was being carried out, over 2 TB of data was seized. Your Honours, if the council will draw a parallel just quickly, that one good quality photograph is worth the storage space of 20 to 50 MB, Your Honours. That makes 1 TB is 10 lakh MBs. That means that the state had to analyze data nearly, this is the data comparative of nearly 1 lakh photos. Not exactly 1 lakh photos, but the equivalent of the data, the size of 1 lakh photos. Your Honours, the council acknowledges the right to counsel that the petitioner has. However, in the application of that legal right, there are practical delays, and the same has to be accommodated, Your Honours. The state was investigating, interrogating various journalists and the data principles of these confiscated data, and the same application calls for certain practical delays, and the same is to be taken into account. Further, Your Honours, no damage has been caused to the petitioner, as she is at the moment being represented by a union of civil liberty lawyers, as has been mentioned in the proposition, Your Honours. Further, Your Honours, as regarding the guidelines, they were just interim guidelines proposed by the petitioner itself. They are not upheld by the Honourable Bench, they are not ordered by the Honourable Bench, and the same may be taken into account that they are merely interim. The case is still a running petition. Further, Your Honours, regarding the passwords that the co-counsel has raised the concern about, the state does have access to her passwords. That is the entire point of a seizure and the investigation. The state has access. The problem is that she should not have access. She has her own passwords, and if she goes out, she will access her data and then delete or erase or remove anything that is self-incriminating.
Change the passwords. What is wrong with that?
Your Honours, the council may, if the council may only contend that there is a lot of other data which is still being procured and being investigated, and the council wants to, the state wants to investigate into that without any interruption and interference by the petitioner.
No, she said, doesn't say interference. She said, give me at least, let my lawyer sit with me. Or why do you grant
Indeed, Your Honours,
grant legal
if
assistance?
the council may highlight the provision in BNSS that states that the person who is arrested has a right to a counsel of their choice who may sit through the person throughout the interrogation, may sit with the person, though not throughout the interrogation, Your Honours. The council humbly contends that the same right is being claimed by the petitioner, and the application of the same on practical ground was a little out of the state's ambit of capabilities. Having said that, if the state, if Your Honours find fault at the state's part, the state would humbly seek apologies for the same, while contending that no damage was suffered by the petitioner due to this right.
One question.
Indeed.
First thing is, if there is extensive evidence,
Indeed.
and it took you more than 36 hours, how is it connected to giving a right of counsel to the petitioner?
Much more.
You may take 60 days, 180 days, whatever, but that doesn't mean that because you were sifting through the evidence
Much more.
or analyzing, they are not entitled to counsel. That becomes a right which accrues immediately on apprehension.
Much obliged, Your Honours. The council is also contending that the 2 TB of data that was seized was not just petitioners. It was also a lot of other journalists, other people from whom the data was seized who were being interrogated and investigated upon. The council may just answer Your Honours' questions. During this investigation, there were only practical delays, and while the council acknowledges the petitioner's right to counsel, in the limited knowledge of the council, Your Honours, the council is not aware of a 24-hour bar.
Can you tell us some judicial precedent on this where the denial of lawyer during investigation, something in recent past?
So my sincere apologies to the bench, Your Honours. However, the council may get back to the
Muzammil has been denied yesterday.
If pardon, Your Honours.
Muzammil, the doctor arrested from Faridabad,
Indeed, Your Honours.
he has been yesterday itself denied access to lawyer during investigation.
Noted, Your Honours. The council shall hold the investigation with note of this observation, Your Honours. The council shall seek to remedy this.
Just last question. On, one hand you were saying that bail should be denied because you are at the final stage, evidence completed, final argument. At the same time, you were saying there is a likelihood of tampering. Whatever evidence was there is already on record, proved, everything done. So this, how would you justify this as a ground to deny bail?
Much obliged, Your Honours. The council is contending that since as there is no physical presence required to access the same, since this is the final stage, Your Honours, to begin, the council should have begun with the statement that this is the final hearing and bail is not required. Furthermore, on assumption that there are more hearings pending, Your Honours, it is intended that tamper with evidence even throughout the proceedings is unlawful, Your Honours. The petitioner is likely to engage in the same, and the much obliged, Your Honours, it was an honor.
The judges are hereby requested to please provide their valuable feedback to the councils.
I would first compliment all of you being so young with a little court practical experience. I think it's a fantastic job for you all. In a moot court, it becomes a little difficult because at times the facts and law does not match the way you all were saying. There cannot be a final argument before Supreme Court. what happens is, oh, this is nothing. I could have done better. Oh, they are going wrong. But to be in the hot seat does give you a different challenge. But this is a lot of learning, and I can only compliment you all, because in the court there is definitely a different kind of young lawyers who are coming, and it's always a pleasure.
See, I never had guts to stand in moot court. We also used to have moot courts.
I never
CLC, I was in Campus Law Center. My teachers would tell me, "के जा बेटा, participate कर." नहीं मैम, मेरे को डर लगता, मेरी टांगें काटती हैं. So first thing, I compliment all of you, everybody those who stand here. Number two, I deliberately put certain questions, some of which were absolutely wrong. I just wanted to see how your response to these questions is. I'll tell you the reason. We, the judges, when we hold court, we are human beings. We are not super intelligent. Many a time we also have certain queries which may not be even sustainable. So a good counsel should be able to respond to even an illogical, absurd, stupid question from the bench. Third thing, which I missed by the time you started your address, that you sought permission to address as my lords or lordships. My understanding is, let's get rid of this expression. This is a feudal expression. We are not my lords. We have simply borrowed that system. So try to avoid this expression. Last word. There will be only one winner, right? Because there's only one slot for number one. But for hard work, there is no slot. You can't say कि जी यहाँ पर 50 लोग अगर बैठे हैं तो सिर्फ 2 लोग हार्ड वर्क कर सकते हैं, बाकियों को अलाउड नहीं है. You can't do that. Each one of us can work hard, and that's the only thing I would share with all my young friends. That develop it as a principle. Work as hard as you can, and a bit more, and every day. That will increase your stamina. Law points, moot court, there are so many restrictions, issues. I can understand you didn't draft the new moot court, so perhaps our mindset attuned to court working, our questioning would be slightly different as it happened in this case regarding final hearing, writ petition in the Supreme Court. So that apart, as Madam also was pointing out, that master your facts first. That's most important. And let's talk best of luck. You are all good.
Respected judges, on behalf of Maharaja Agrasen Institute of Management Studies, I extend our heartfelt gratitude to you for gracing this competition with your presence. Your insightful judgment, constructive feedback, and expertise have made this event a truly enriching experience for all participants. Thank you for your time, guidance, and encouragement. I request the participants to leave the courtroom and would request the judges to please stay in the courtroom. The judges are requested to please fill the scores on the score sheet provided.
and such valuable feedback.
Thank you.